I'm pretty sure you're all familiar with the boiling frog metaphor. Well, when it comes to UK justice, the pan is pretty much boiling. Consider what we've lost in recent years. We used to have the right to remain silent, and this was very important. Essentially, it meant the state had to prove you were guilty of wrongdoing. There was no requirement on the individual to prove or otherwise demonstrate their innocence. But that largely disappeared with the Criminal Justice and Public Order Act 1994. Now courts are allowed to draw negative inferences if someone remains silent. This was a pretty fundamental shift. They're essentially saying, account for yourself, pleb, to our satisfaction. Well, no thanks, my lord, I'm not your serf. Then double jeopardy was abolished. The killing of Stephen Lawrence in 1993 was a very high-profile case in the UK, and the facts are not entirely clear even now. But there was a strong suggestion that 4 individuals were responsible for the murder. However, there were apparently procedural errors in evidence handling, which meant the principal suspects could not be tried in the normal manner, and the subsequent private prosecution failed. That should have been the end of the matter. Now, would it have meant guilty people went free? Yes, almost certainly, but that's the price we pay for giving the state one shot. However, double jeopardy was abolished, and the 2 primary suspects were retried and convicted. It seemed to me almost impossible for these men to get a fair trial, even though it's extremely likely they were in fact guilty. Sir William Macpherson in his report suggested double jeopardy be abolished for murder. However, the government took this as carte blanche and abolished it for around 30 offences. This is an absolutely dreadful power to give to the state because the potential for abuse is almost endless. They can keep investigating, keep finding new evidence, and in theory you are never innocent. It's just an interlude between trials. And now we have our erudite and learned Deputy Prime Minister proposing to abolish trial by jury. This is perhaps the most egregious of all. This ancient right was first granted to us by the Magna Carta in 1215, and though annulled by the Pope shortly afterwards, it was reissued, revised, and confirmed by Henry III and Edward I. Yes, even the evil Longshanks of Braveheart fame, with the 1297 version becoming statute law, solidifying its place in the English canon. The Magna Carta didn't invent modern trial by jury, but it laid some of the groundwork. Clause 39 protected free men from imprisonment except by the lawful judgment of his peers. This inspired later concepts of justice by equals and due process. While judgment by peers in 1215 meant social equals, not on modern juries we understand it, it became a cornerstone of evolving legal rights, and along with some Saxon additions, it eventually led to the principle of trial by jury as a key safeguard against arbitrary power. This was not unchallenged. Starting in the 1480s, the so-called Star Chamber operated without juries. It became notorious for unfair, secret, and oppressive procedures, leading to its abolition in 1641 as a symbol of tyranny. Are we really suggesting we should bring back the de facto Star Chamber for administrative convenience? What's next? Trial by ordeal? The rack? Our criminal justice system was designed for a largely law-abiding population. We no longer have that. The courts are overwhelmed and prisons are full. We no longer have a common set of values that almost all of us subscribe to. Criminals used to be rare, a small minority of people. Now they're endemic and quite often ignored by law enforcement. If they do make it to court, oftentimes there are no jail spaces, and at the completion of sentences, even the worst offenders aren't deported. Our criminal justice system is failing. It can't cope with the sheer volume of crime, but the solution is not to strip away the ancient judicial safeguards. There are much better options. And first among them must be the mandatory deportation of any criminals, regardless of the circumstances they might face in their home country. This would act as a powerful disincentive to crime, and it would solve prison overcrowding at a stroke. There are around 11,000 foreign criminals in British jails. That's nearly 12% of capacity. We need to do this immediately rather than abolish trial by jury.